kLbn7QGuTUk. And I appear on behalf of the defendant in this matter, Lorenzo Morris. State your name, please.
Lorenzo Allen Morris.
All right, thank you. Today is the day set for the continuation of the trial that was started. With respect to the trial, the sequestration order is still in effect. Are there any other preliminary matters before we begin?
Not for the people. Now on behalf of the defendants.
All right, then the defense may call this next witness. Thank you. I was trying to multitask. The people, because let me tell you, Ms. Ritter was like, do not call me. One day she knows. The people may call their next witness.
Thank you, Judge. At this time, the people would like to call Mr. Marlon McDonald.
You may. All right, step this way. Raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may be seated. Ms. Ritter, you may proceed.
Thank you, Your Honor. Good morning, Mr. McDowell. Mr. McDowell, can you state your full name to the record?
Yes, Marlon McDowell.
Thank you. And Mr. McDowell, you were present last Friday, when we started this trial, is that correct?
Yes, ma'am.
And between last Friday and today, did you view any videos regarding any testimony that was taken, last week?
No, ma'am.
Okay, thank you. So, Mr. McDowell, I want to go back to December 16th of 2019. Where were you employed on that day?
At Detroit Public School, Central High School.
Okay, and on December 16th or about December 16th, 2019, how long were you employed with Central High School?
Before that, it was, for 5 years at Central High School.
Okay, and Mr. McDowell, there's a microphone in front of you. If you can
Yes,
speak into the microphone, if you need to adjust it, then adjust it. Just make sure you speak up, keep your voice up, as the court reporter is making a record as well, okay?
Yes, ma'am.
Thank you. And can you repeat how long have you been working with Central High School?
All together or just now?
From 2019,
5 years.
5 years. Okay, and what was your,
I apologize. The answer to the question, he had, as of 2019, you have been working there 5 years?
Yes, ma'am.
Thank you.
and what was your position at Central High School on about December 6th of 2019?
Dean of Student, Dean of Culture, Central High School.
Okay, now, on December 16th of 2019, was there an incident that occurred at the school?
Yes, ma'am.
Okay, do you recall what happened on that day?
I can't recall, the reason as far as like the meeting, like that preceded, the incident. But, I do recall there was an incident that happened as far as was just a meeting inside that office area, inside the room. So I'm not sure, I can't remember the incident, because I didn't try to go backtrack or anything like that, as far as the incident that happened that day.
Okay.
I'm not sure.
Okay, let's go back just a little bit, Mr. McDowell. So, you stated that there was something going on in the main.
It was a meeting, right, it was a meeting in the office, in the conference area.
Who was in that meeting?
I believe it was Mr. Morris in that meeting, in that conference area.
Okay, do you recall who was in the room?
Before the incident, I'm talking about part of just before the incident happened. I know there was a meeting with, Ms. Tillman and I believe Mr. Sewell and Mr. Morris inside that meeting.
Okay, so let's talk about before this incident occurred.
Right.
So do you recall anything from that meeting?
Just as far as the meeting was, the door was closed, so I can't really say what was going on.
So where were you?
I was on the outside of the door, during that time, and it just seemed like there was some arguing going on back and forth.
And why do you say it seemed like there was arguing?
Just, the hand motions and you can hear it from the outside, at all.
Okay, and what room were you in when you could hear the
I was in the
argument?
main
Hold
area.
up, Mr. McDowell, let her finish completely her question and then start your answer, because you all are kind of overlapping. What was your question?
Where were you when the meeting was taking place?
I was in the main office area.
Oh.
Just in like that corridor area, part of it, in the main office.
And do you recall where the meeting with Mr. Sewell, Mr. Morris, and Ms. Tillman was taking place?
That's Tillman's office.
Okay, and from what, if you can recall, from, the main office, where's Ms. Tillman's office?
It's right in that sector, so it's over to the right, like closest to like Central High School, to the front of the building.
Okay,
So it's over to the right. It's in that same area.
okay, and what happens after you hear this argument going on in the office?
I seen, Mr. Morris, he comes out first, and then it was, Mr. Sewell comes out behind him, then there was a little bit more shouting going on between the two.
And where were you at this point?
I was still standing there in there, so I was trying to proceed, trying to see if I could intervene, just to be able to kind of like make sure that nothing happened.
Did you intervene at that point when they were going back and forth? as
Well,
far
yeah,
as
I
the
was just trying to say, like, just try to break it up, and as also Officer Shane, she was there as well, trying to, intervene, making sure that nothing kind of like went physical.
Okay, now let's go back just a little bit. So the person that you're referring to as Mr. Morris, do you see them in the courtroom today?
Yes.
Can you point them out and tell me what they are wearing?
He ran a blue shirt, blue sweater vest, and, blue tie as well.
Judge, may the record reflect the identification of the defendant, Lorenzo Morris.
The record will reflect the identification of Mr. Morris.
Thank you. And then you, mentioned Officer Shane. The person you're referring to is Officer Shane. Do you see that person in the courtroom?
Yes, ma'am.
Can you point them out and tell me what they are wearing?
She's wearing a blue shirt, blue sweater, with blue collar, and I can't see anything else.
Okay, so where are you when you say you try to perceive if you can intervene? Did you?
I'm probably maybe about 10 to 15 feet away from the incident.
Okay, and at that point, did you intervene?
Yes, I was just trying to step in between. I didn't kind of like make it there in time. I believe Officer Shane, she did, and that's when kind of like the situation happened from there.
Okay, so let's go back just a little bit. So when you say Officer Shane, or sorry, strike that. When you say you couldn't make it in time, where were you standing at that point?
So there's a table that's in between, like by the office, like in that main area. So it's like just a table in that main area. So sometimes it's like a waiting little table that people sit at. We got a meeting there or anything. So we're in that area. It's a printer, and there's 2 clerical desks that's in that area. So I'm in that middle area, and you have Ms. Tillman's office over to the right. So
Okay,
they're at the corner of the office.
okay, and where is Officer Shane from where you're standing? Where is she?
She's coming in, she's hearing it, and she's proceeding.
Objection as to him trying to describe what Officer Shane was hearing or.
Sustained.
From your observation, Mr. McDowell, where was Officer Shane? From your observation, not what you heard, not what you think she heard, but from your observation, where was Officer Shane?
Proceeding to the situation. She was in the process of moving towards the situation that was occurring.
Okay, now, do you recall, if she was walking in a fast pace or a regular walk towards where the incident occurred?
I believe she was proceeding with caution, like where she was moving forward, like where it wasn't like an aggressive run or anything like that, but she was just proceeding to hearing it. So, I mean, she wasn't, where it was like, I need to get this person or this person. It was just a point of just an act of in between or going in between.
Okay, and.
1 second. Ms. Stevenson, are you ready on, the tether violation?
Ready, Your Honor.
All right, everyone stay in place, just give me one moment. This is case number, oh, hold on, is this a felony or is this a misdemeanor?
You do have she has a misdemeanor tether on for your case, Your Honor.
I didn't receive a tether report, Judge. I just got it, I'm sorry. Here. But let me ask this, so does she have to go see Judge Dow? Did he put a tether on her?
That case got dismissed, Your Honor, at exam.
Okay. Yes,
Can I use the restroom?
yes, yeah. Okay, so I'm sorry, I didn't read the case number. I gave Ms. Ritter my papers. That's okay, Ms. Ritter. I mean, keep it. Do we have the case number? All right, thank you. All right, I have it. This is case number 234520501. The people versus Diana Lucia Castaneda. And the defendant is charged with, okay, looks like she's charged with assault or assault and battery, and today is the date set for, well, it's not the date set. She was brought before the court on a tether violation. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Diana Castaneda. Ms. Castaneda, ma'am, please unmute and say your full name.
Can you get the deputy to unmute? What have they left? What the hell? Oh, there it is. Okay, can the deputy unmute you, ma'am? All right.
Diana Lucia Castaneda.
Say it again.
Diana Lucia Castaneda.
All right, today, the defendant has been brought before the court on a tether violation, and I had an opportunity to read the tether violation, and according to the tether unit, she was placed in the tether program. She was placed on the tether by Judge William C. McConaughey. She was put in the tether program. She was explained what the tether program was, and she agreed to go to a place. She agreed that she was gonna be residing at a house. And then the tether unit was monitoring the tether, and then they went to the place that she agreed to be tethered to, and the people that was living at that house said, we haven't heard from her since she got out of jail. Ms. Stevenson?
I believe, first of all, that this matter, because the complaining witness is Ms. Castaneda's mother, we believe ultimately this case would transfer to the domestic violence docket. I would have no objection to waiting for Judge Garrett to rule on the removal of the tether, Your Honor, and I would be suggesting that if the tether is going to stay on, that she be tethered to Naomi's nest if they have availability for her.
The tether is gonna stay on. I'm glad you think you know me, and you might. The tether is gonna stay on. She never even made contact with the people who she was supposed to be tethered to. So that sounds like it was a dishonesty. And since it is domestic violence, we're gonna go ahead and transfer the case to Judge Garrett. We're gonna put it on his, a docket for the same day. So they put it on my docket for October 30th. We're gonna just put it on Judge Garrett's docket, let them know, call them and let them know that I'm transferring it based upon the familiar relationship between the parties. The tether is going to remain, and the court will allow her to be tethered to Naomi's nest if they have an appropriate bed for her. Anything further?
Thank you, Judge.
Nothing on behalf of Ms. Castaneda. Thank you, Your Honor.
Let me just also be clear about this too. The tether conditions that Judge McConaughey imposed at the bond redetermination hearing, those tether conditions are all the same. she's house arrest at Naomi's Nest until Judge Garrett decides what he wants to do with the tether, okay? And
Thank you,
then
Your
there's
Honor.
right, McConaughey said she's allowed to travel for court and medical only. And so those are the same bond conditions, but we're gonna just change the tether location to Naomi's Nest. And she's only to be tethered to Naomi's Nest or a like facility. That's my order. Naomi's Nest or a like facility. Anything further?
No, thank you.
I think on behalf of Ms. Castaneda, thank you, Your Honor.
All right, and then we'll send over the paperwork to transfer her next court date to Judge Garrett. Oh, there, Sergeant, you're there, so I think you heard what I said, but tethered to Naomi's Nest, and I'm transferring the case to Judge Garrett.
Yes, Judge, understood. Thank you very much.
All right, thank you, Sergeant, have a great day, stay safe.
You too.
All right, thank you. Okay, excuse that interruption, but yes,
Mrs. Jefferson client is outside, Your Honor.
okay, they'll be out here. Okay, you can keep it. Okay. All right, excuse the interruption, and Ms. Ritter, you may continue.
Thank you. So Mr. McDowell, just repeat my last question. Do you remember at what pace or in what manner Officer Shane was proceeding towards the incident?
I think she was proceeding just, nothing aggressive or anything like that. She just proceeded to the situation, I guess, as a person in concern, part of what was going on. It was kind of like maybe a brief speed to it, but it wasn't nothing running or anything like that.
Okay, and what happened next when Officer Shane proceeded to the incident?
It was yelling between Morris and Sewell, and I guess Sewell asked him to leave, or he said that he was leaving, and Shane kind of like had her hands up,
And where was she standing when she had her hands up?
like right behind them, or like in the middle of
And when you say behind him, who are you referring to?
them, behind Mr. Morris, like kind of like in the middle or behind Miss Morris, because she didn't get there kind of like quiet in time, and that's when Mr. Morris just kind of like pushed her off, and just proceeded.
Okay, so when you say she had her hands up, can you show the court what you mean by her hands up?
Just like this. Just
Can you
like,
stand up and show me? Okay, thank you.
Okay, and you said when she had her hands up, she was either behind Mr. Morris or in between Mr.
Right,
Morris and
right.
Mr. Sewell?
yes,
Okay, and then you testified that Mr. Moore then pushed Officer Shane?
yeah, I believe like push
Objection,
her.
that's not what, excuse me, objection. That's a mischaracterization of what his testimony was. He did not use the word as a push. I didn't.
He did, I wrote it down on my paper. He said Mr. Morris pushed her off. That's what I wrote on my paper. Overruled.
Thank you. And can you repeat that? I'm sorry, Mr. McDowell.
Well, what is he repeating it for?
But me, so I can remember
Okay.
Cause he felt like pushed her hand away. I'm not sure if it was like a zone or anything, but it was just like he pushed it. Can't say anything like psychological, but it's just, I'm not sure if he just like pushed off and just kept on proceeding.
And where do you recall him pushing Officer Shane?
It
Did you
was
say
like-
where?
Yes.
Okay, thank you.
Like in the hands and just the hands area.
Do you recall how many times he did that?
It was just one.
Okay, and what, do you recall from your observation what Officer Shane did next?
She's more like in shock, and that's when she was stating that was assault far as with him pushing her and putting his hands on.
And where were you at this point when this happened?
I kind of like was going in between, but he had already proceeded, because it was kind of like more of a situation where, I was trying to let her handle it as a police matter now, whatever the situation was.
Okay, and when you say he proceeded, who are you referring to?
Say that again.
When you say he proceeded, who are you referring to?
What you mean he proceeded? I said, I proceeded to the situation part was just closer to her.
Okay, and where was Mr. Morris at that point?
He was like gone out the door by that time.
Okay, and Do you recall what happened next?
It was more as far as with, and like, more people was in more like disbelief and just like shocked about how the situation went. And it was just kind of like he had left and it was just kind of like everybody was trying to calm down from there from the situation.
Okay, do you recall the police, coming to the high school?
Yes, I do believe the police did.
Do
I
you-
don't recall, I can't recall, but I do believe they did, but I can't remember.
Okay, you don't remember?
Yes.
Okay, Judge, may I have one moment?
You may.
Did I share my screen?
Yes.
Okay, looking at the monitor in the courtroom, Mr. McDowell, do you see the monitor in the courtroom? Can you see?
Yes, ma'am.
Okay, and looking at the monitor, do you see yourself on the screen?
Yes, ma'am.
Where do you see yourself? Can you describe what you're wearing?
Blue shirt with the khaki pants.
Okay, and do you recall what this still screenshot is?
Yes, that's the situation that happened, the reason why we're here today.
Okay, Judge, at this time, we are asking the court permission to play people's already admitted exhibit 1.
You may.
No objection, I just need my glasses.
Okay.
Thank you.
And, are you playing it from the beginning or are you playing it from this spot on here?
The beginning. Your Honor.
Okay, thank you.
Okay, so, Mr. McDowell, I'm gonna start the video from the beginning, and I want you to watch the video, and I want you to tell me when to stop. When you testified that this, Mr. Morris pushed Officer Shane, okay?
Okay.
So Judge, at this time, the people will start the video at 0 minutes and 0 seconds.
The area right there. Go back maybe like, like 23, 24 seconds.
That's a lot of seconds.
Like the 20, between like the
That's the
23. No, don't go back 23
So,
seconds.
wait,
Go back
wait.
to the 23 mark.
Okay. Okay. Okay, so the instructions are this. When you see on the video where you say, Mr. Morris, pushed the Officer Shane away.
But
Say-
the objection, this is my, he said pushed her hand away.
Okay, whatever that might be, I'm just telling you where the instruction is. When you see that on the screen, say stop, like that. That's what I want to stop, or whatever your voice is, you know, mine is higher than yours. You stop, stop,
Stop.
right, stop,
Okay.
stop.
Like that.
Okay, stop, all right. So go ahead. So she can stop right away.
Okay.
Okay,
Go back a little bit further.
go back 23 seconds.
No, go back.
Okay, I'm gonna go back to the beginning.
Yes, please. Stop.
Ms. Ritter, now you wanted to do the trigger.
I wasn't.
Okay.
Okay, one more time, for the record, I'm going back about 18 seconds.
Stop.
So for the record, the video stopped at 20 seconds. So looking at the screen, Mr. McDowell, is that consistent as to what you testified to in the courtroom?
From My memory, kinda no, but yeah, I mean, because of the simple fact, like, I didn't see the video, I haven't seen the video. And it's been 4 years since the situation.
But from what you remember,
From what I remember, yeah, it's kind of similar to what I seen, but,
okay,
I didn't know I was that close to the situation.
okay. Judge, I have one moment. You may not stop sharing the screen.
Okay,
Couple more questions, Mr. McDowell. You said you, at that point, about 2019, you had been working at Central High School for how long?
Over 5 years.
Okay, during that 5-year tenure, was Officer Shane employed with Central High School as well?
Yes, yes, ma'am.
And was Mr. Morris employed with Central High School during that 5-year tenure of yours?
No, ma'am. He was there, I believe that was the first year or maybe possibly the second year.
Okay, so he hasn't been employed with Central High School that long?
No, ma'am.
Do you recall what Mr. Morris' position was at Central High School?
I think he was a paraprofessional,
Can you just
or
explain that?
ESE. He was a parapro, like where he worked with the ESE, the special needs students. He serviced them at the aid inside the classroom.
Okay, and now is that a teacher? Did he have any teaching,
I'm not sure. I don't believe he taught, but he possibly could have tutored or anything inside that classroom as well.
okay, and from your recollection, did Officer Shane and Mr. Morris, from what you recall, what you know, from your personal knowledge, have they had any prior contact with each other before this incident?
No, not to my knowledge.
Okay, and I'm sorry, Mr. McDowell, where's Central High School located?
2425 Tuxedo.
Is that the city of Detroit,
Yes, Detroit, Michigan.
county of Wayne?
Yes.
Okay. I have no further questions.
all right, cross-examination.
Yes. Good morning, Mr. McDowell.
Good morning. How you doing?
I'm good. How are you?
Doing good.
I'm gonna ask you a few questions. If there's anything that I ask you and you don't understand, just ask me to repeat it, okay?
Yes, ma'am.
I just want to get a better understanding as to what happened in your perspective on that day. Okay?
Yes, ma'am.
So now let's see. You saw the video and you say that the officer, when you saw that video, it's still your testimony that she just walked up in a concerned way or not an aggressive way? Is that, do you change your testimony from that after seeing
Well,
the video?
no, only thing I would change, like, far as with, it still seemed like she was concerned about the yelling and the altercation just between two adults being face to face and inside of a school building just is unprofessional. So that's probably, I seen what I see more proceeding to that, just a concern of nothing else, and the hostility in both of the voices of the adults.
Okay, so number one, you say that there was hostility in both of the adults.
Yes,
Is that
ma'am.
correct? Those adults would be Mr. Sewell and Mr. Morris. Is that correct?
Yes, ma'am.
All right, and then the next thing you say is that you see her approach and it's just more as a concerned way. That's, even after you saw the video, it's just more concerned.
Yes, ma'am.
And then you testified that she came up and she had her hands out, or she had her hands out wide, in front or out wide?
Well, it wasn't like to touch or proceed. It was just like a barrier, just to bring space in between those two individuals, because they were close and face to face.
So when you bring space, is she doing it up?
No, she didn't, I didn't see any touching.
Just let me finish my question.
Yes, ma'am.
Okay, a demonstration. So when you first showed us, your hands were out front. Are you saying her hands were out front between the two gentlemen, or were her hands kind of going between the two gentlemen?
Judge, I object to this characterization. He didn't put his hand out front.
Overruled. She's asking them which it is, so overruled.
Well, you can answer.
I can answer that?
Yes, you can answer.
So, it's just, they were out. I mean, I'm not saying like they were out. They were just out to create space. I haven't seen her do it. As far as just an interaction, as far as with an altercation, And just to see if that can help create space between the two individuals.
Okay, but at that point, that's just what you think she was doing. You don't know what was in her mind, isn't that correct?
No, ma'am, I don't.
And you don't know what her intent was. Okay, so now, and that's correct, you don't know what her intent was, correct?
No, ma'am.
All right. So now, and it's your thing, and you testified that did he push her hand away when she had her hands up?
Well, it was in the parts where his manner was aggressive. So I think anybody like that was trying to touch him or anything like that, and he just pushed it away. He was angry at the time.
That wasn't, okay, that's the answer, that's your answer to my
That's what
question.
I guess. Yes, ma'am.
Okay,
So are you, can you repeat what you're asking?
absolutely. And in fact, Madam Court Reporter, can you tell me what my question was?
And in your testimony, you testified that he pushed her hand away when she had her hands up.
So did he push her hand away when she had her hands up?
Yes, ma'am.
Okay, all right. And it is your testimony that this only happened once?
That's what I see. Yes, ma'am.
Okay, and isn't it true he didn't shove her?
I didn't see far as with like a shove in that manner. I can't recollect that. I can't recall. I can't say yes or no. I really know if he really shoved her, but all I see is the hands of the pusher. Yes, ma'am.
Okay, you saw him push her hand away, is that correct?
Yes, ma'am.
All right, and let's see, no, one moment, please. Okay, thank you very much. I don't have any further questions. Thank you.
Any redirect?
Oh, thank you, Your Honor.
I have a question for you. Mr. McDowell, you said that, let me find it. I think you said that you tried to intervene. Is that what you said?
Right.
Okay. My question is, why did you try to intervene? What were you trying to intervene to?
As far as was just yelling, it was something that I didn't see from both individuals. I haven't seen before as far as with Mr. Sewell, as far as with him being irate and with the behavior, so I just started to intervene, just try to stop them. You know, two males and two adults having some type of altercation inside the building.
So when you observed whatever was going on from a distance, because you said you were, over somewhere else, it was your assessment that it was an aggressive situation?
Yes, ma'am.
Okay,
Well, you can hear it from the office, as far as with them going back and forth. What made it, I guess, proceed to whatever thing they were arguing about, I guess, being over. And I guess it was just trying to get the final words, but I'm not sure what was said in the office or anything.
okay, but when you saw it and heard it, it was your response to attempt to intervene?
Yes, ma'am.
Okay, thank you. Are there any questions based on my question?
The people do have a few questions.
Okay,
So based on the judge's question that she asked you, why do you feel the need to intervene? Do you recall what Mr. Morris's demeanor was at that time?
Yes, ma'am, it was aggressive.
And do you recall what Mr. Sewell's demeanor was at that time?
It was like hostility parts with, I guess, as far as with it was aggressive behavior as far as with his as well, but it was more like hostility, just an argument and just loud. It was loud. His was just more loud.
Okay, and when you say you try to intervene, was this the, I guess, the argument between Mr. Sewell and Mr. Morris?
Yes, ma'am.
Okay, no further questions.
okay, counsel, did you have any follow-up?
No,
All right, thank you, sir. You may step down, and this witness is free to go.
the people have no further questions.
Okay. You're free to go, like, leave if you want to. Leave. Okay. Okay, and are there any other witnesses on behalf of this board?
No, thank you, Your Honor, the people who rest at this time.
Okay? Anything on behalf of the defense at this time?
Yes, the defense would like to make a motion for directed verdict.
Okay, you may. Is Ms. Jefferson out there also?
No, the client said she was waiting on Ms. Jefferson to show up, but I can check right now.
Oh, okay, just check. I mean, I'm gonna do it after this motion though, but see if she's in the area. Okay.
Your Honor, the motion for directed verdict, it is to be considered in the light most favorable to the non-moving party. And I'm bringing this because I don't believe that people have shown beyond a reasonable doubt how completely they've proven their case. What we've heard is that we've heard from two independent witnesses, and we actually have seen the video as well. There was no shove. Well, I don't recall. They recall maybe a hand being pushed out of the way, but they also say about Officer Shane coming up to either putting her hands between the both of them or putting her hands up. And I can certainly see she started that aggressive behavior. She approaches, fine, that's her job, she approaches. Now, but what we don't see is this actual shove. Even in this video, we've seen this video about 10 times, there's no shove. We don't see where she goes backwards. We just don't see that. So her, the movement of pushing her hand away, when her hand is up in someone's face, or not in someone's face, but up, and trying to stress her own testimony is that she's trying to keep them apart. Now, Mr. McDowell says, oh no, her hands were just out. Ms. Tillman, her hands were, Mr. McDowell, hands were out. Ms. Tillman, hands were out towards each other, towards each gentleman. Not one of those people said that there was this push. This is the shove that she was shoved in his chest whatsoever. That does not come up. Neither one have testified to it. And the video does not portray that. The video portrays that yes, there's some type of discussion. We hear by all the witnesses that it was aggressive. Everybody agrees that it was aggressive. Everybody agrees that, except for I didn't ask Mr. McDowell, no one asked Officer Shane to approach, to come forward. They were handling it. She comes forward in that video, whether or not the speed was increased or slowed down, the way she approached was not in a kind, concerned manner, cautious manner whatsoever. We see her stand in between. This is what the video shows. We don't see at all where we don't see in that video where Mr. Morris, my client, touches her whatsoever. We don't see that. It just is not supported. And for those reasons, I don't think an assault happened. I don't think a battery happened with the present sensibilities. There were people around. That actual physical touching, the video doesn't show a touching. I don't think the people have proven beyond a reasonable doubt that they haven't proven their case. They haven't proven it. And I'm just asking that the court dismiss the case and grant the motion.
Response.
Yes, Judge. So Judge, if the court is looking at the motion in favor of the non-moving party, in light of favor of the non-moving party, I'm gonna ask the court to deny defense counsel's motion, Your Honor. The people did present 3 witnesses. The complainant witness, Officer Rochelle Shane, an eyewitness, Assistant Principal Sheena Tillman, and the Dean of Culture, Mr. Marlon McDowell. Now, Judge, setting the video aside, these 3 witnesses have all testified to this court that there was some argument between Mr. Sewell, who was the principal of the high school, and Mr. Morris. All 3 witnesses have testified that there was arguing between the two, and that the noise and the voice levels of the argument increased in a manner in which Mr. McDowell testified that he wanted to proceed towards this incident to try to intervene because he felt like it was an aggressive nature ensuing between the two. Officer Shane had testified last Friday that she came out of this conference room because of the noise level and concern and wanted to intervene and see what was going on between Mr. Sewell and Mr. Morris. Ms. Tillman has testified last Thursday, Your Honor, that, she was inside of her office and she can hear the noise level so loud between Mr. Morris and Mr. Sewell that she came out to see what was going on. So all three witnesses have testified, Judge, that Officer Shane has approached this incident between Mr. Sewell and Mr. Morris. And Officer Shane has testified that when she approached, that she was pushed. I think her testimony was a couple times. Ms. Tillman has testified that when she observed the incident, that Mr. Morris pushed Officer Shane's hand away so hard that her hand flew away. Mr. McDowell testified that when he perceived the incident, from what he saw, Mr. Morris pushed Officer Shane's hand away. So I'm bringing that to the court's attention because to establish the people's verdict, we have to establish that there is a forceful or violent or offensive touching. Now, whether the witnesses saw Mr. Morris push Officer Shane, or whether the witnesses testified that Mr. Morris pushed her hand away, or whether the witness testified that Mr. Morris slapped Officer Shane's hand away, that's a credibility issue, Your Honor, and I feel like that's a credibility issue for the trier of fact. So as the court is looking at the motion in favor of the non-moving party, I'm gonna ask the court to deny the defense counsel's motion. I believe that the people presented these three witnesses, not even bringing in the video, just the testimony from these three witnesses, there is a consistent recollection of the events of this incident that is sufficient enough for the trier of fact to establish that the people met their burden of proof at this point. So at this point, Your Honor, I'm gonna ask the court again to, deny defense counsel's motion.
Any rebuttal?
No, Your Honor.
All right, the court viewing the motion in the light most favorable to the non-moving party. The court agrees with the people that the three witnesses established enough evidence on the record for the court, who is in this case also the trier of fact to conclude that there was an offensive, violent, forceful, or offensive touching of the person of another or something closely connected to the person of another, and I'm going to deny defense counsel's motion for a directed verdict. The court having denied the motion for directed verdict, is there anything further on behalf of the defense?
Yes, I'd like to call my first witness.
All right, is she out there?
No, Your Honor.
Okay, let me check the room and see if Mr. Well, I did tell them 11:45, so technically they had 4 minutes, 3 minutes, but okay, the defense may call their first witness.
And then I'd like to volunteer my client just to make sure.
Oh, is your client your witness?
Yes.
The witness, okay, well then stand up, Mr. Morris. State your name, sir.
Lorenzo Morris.
Mr. Morris, it appears that your lawyer is going to call you as a witness. Do you understand, Mr. Morris, that you have the absolute right to remain silent?
Yes.
Do you understand that if you give up the right to remain silent and testify, that the court is going to use your testimony in connection with the other witness's testimony to make a decision in this case?
Yes.
Sir, has anyone threatened you in any way or promised you anything that was not placed on the record to get you to give up your right to remain silent and to testify in this case?
Ma'am.
Do you understand that the decision to testify is yours and yours alone, but in consultation with your lawyer?
Yes.
You've spoken with your lawyer about testifying?
Yes.
After speaking with your lawyer about testifying, is it your decision to testify?
Yes.
All right, court is satisfied. Did you want to do any further for dear, or is that
Oh,
sufficient?
no, I'm satisfied.
Thank you. Mr. Morris, you may come towards me. And then raise your right hand, sir. Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may be seated in the witness box. You may proceed.
Thank you. Mr. Morris, I'm gonna ask you some questions so that the court can, so that we can all hear your version of what happened on December 16th, 2019, okay? So when I ask a question, just wait for me to finish my question before you answer. You will be able to say, within reason, because if it's something that's not supposed to go on the record, or you'll be stopped, okay, there'll be objections, but just you'll be able to say what happened to you on that day, okay?
Okay.
And if there's something I ask and you don't understand, just ask me to repeat it. Is that fair?
Yes.
So on December 16th, 2019, where were you employed?
Central High School,
And how were you employed? And what was your position or title?
trainable aid,
Repeat that.
trainable aid.
Trainable aid.
Trainable aid.
Okay. And in that position, what exactly did you do?
Well, I assist the lead teacher with the, special needs students.
And is that, assisting, does that, as far as teaching, as far as controlling the classroom, what do you do?
Okay, yes, I assist with tutoring, helping them in the classroom, teaching and everything. I also, I have to get there in the morning and be there for the kids getting off the bus, so I get there early. And I leave late because they have to get the bus, so I have to wait till the last student leaves. I also take them to the classrooms. They have a couple classes that they do. They stay in there half of the day there in one class. The other half, we go to lunch, we go to music, and sometimes we go to the gym, and I escort them from to and from.
Okay, very nice. Is there anything else you were doing at Central High School? Any other duties?
Yeah, I'm a football coach.
And were you the head football coach at Central, or what was your capacity?
Well, my capacity, I was like defensive coordinator.
All right. And how long have you been employed with at Central High School?
Well, I had returned to Central High School that semester. However, I've coached at Central High School since 1990-91. I left there in 2000 and, I believe 2003. I coached basketball, football, and track.
Okay.
And I left there, went to Southfield, and then I came back over there to help out Coach Macon, him and Mr. Sewell. We met on the 24th of August before I went to the career fair to be hired. He asked me to come over. He didn't give me the position that I should have because.
Okay, we don't have to go there. Just to stay focused
Oh, okay.
on how long you were, it was about, did you have any other duties at Central High School? And you said yes, the
Football.
football coach. Thank you. So now let's talk about December 16th, 2019. And let's start about, you started your day off getting the children off the bus.
Yes,
At some point in time, did you get called down to the office?
yes, I did.
And do you know who called you down to the office?
Well, it happened, earlier in the day. I had to take two students down to
Wait,
the
let me
office.
stop.
'Cause they
I want you
called
to
me.
know, I need you to answer, listen
I'm
to my
sorry.
question and answer it. Okay, that's what I need you to do. The question was, who called you down to the office?
Mr. Sewell.
Okay, and approximately what time did he call you down to the office?
Mr. Sewell was on the intercom. It was roughly 1:30, about 1:30.
Okay, so then you go down to the office. Did you know why Mr. Sewell wanted you to come down to the office?
Yes,
And when you got down to the office, did you talk to Mr. Sewell? What did you do when you came down to the office?
when I came down to the office, I spoke to, Mr. Robinson in the lobby of the main office. Robinson is the social worker for the, special needs kids.
Oh, understood. Now, did Mr. Robinson have any idea why you had been called down to the office?
Yes, he did.
All right. Now, once you discussed with Mr. Robinson the reason, what did you do next?
Well, I, was told by Mr. Sewell, came out of the conference room and broke up the conversation that me and, Mr. Robinson was having and telling me, come on in the office,
Come on, in the office or to the conference room?
into the conference room.
Okay, and when you got into the conference room, who was in the conference room?
When I got in the conference room, there was, two of my students, Officer Shane, Mr. Sewell, the girl's parent, the mother was there. And, I don't remember anybody else.
Okay, and then how long were you in that conference room before, at any time did you leave the conference room?
Yeah, well, I had to leave the conference room. Mr. Sewell asked me to come out, step out.
Okay, how much time had you been in the conference room before Mr. Sewell asked you to leave the conference room?
It wasn't 2 or 3 minutes.
2 or 3 minutes. And what was the conversation that you were in? Do you know why Mr. Sewell wanted you to leave the conference room?
Yes,
And what was your understanding as to why he wanted you to leave the conference room?
I didn't agree with how he was disciplining, the kids or whatever. I didn't agree with it, and he wanted me to tell the parents something that I didn't agree with.
Okay, so when you say something that what does that mean? He wanted you to lie? What did he want you to do?
Yeah, he wants me to cover up everything. The young lady was punched in the eye, and both kids are in my class.
This is non-responsive. I don't need to know this.
All right.
Okay.
So now, at that point, when you are leaving, what was Mr. Sewell's demeanor?
Mr. Sewell was angry. He was angrily asking questions in the meeting, and then he asked me to leave out after I was questioned by Officer Shane.
So Officer Shane questioned you in that conference room,
Yes,
and what did she ask you?
she asked me what is an abrasion on the girl's eye.
Okay.
Just for the record, the relevance.
Well, you're
I'm
right.
allowed.
Okay. You can answer.
Yes, she began asking me about what happened to the young lady. Well,
So did you explain what happened to the
I
lady?
explained to her that when I got to the young lady.
No, did you explain what happened?
Yes, I did.
Okay.
All right. So then at that point, after you explained what happened, is that when Mr. Sewell asked you to leave the conference room?
Yes.
Now, at this point, when you and Mr. Sewell leave the conference room, how do you all leave the conference? How are you feeling at this point?
Well, at that particular point, I was like, I'm not going to lie or anything. I just walked over to the other office. I said, I can't do it, Mr. Sewell.
Okay, and what were you saying, what couldn't you do?
Well, I couldn't go in there and act like nothing took place or no one was harmed or anything.
Okay. So then at this point, you, Mr. Sewell, both of you leave this conference room together, or you leave first and he follows you? Do you remember what happened?
Yes, I remember. I walked out of the conference room after he told me to go out the conference room. He came out behind me and he said, let's step over into Miss Tillman's office.
When you left this conference room, were you yelling?
No,
Were you screaming?
no,
Were you swinging your arms?
no.
How did you walk out of the conference room into Miss Tillman's office?
Very calmly, and I looked over and I spoke to her when she was in the office.
Listen to my question. Did Mr. Sewell say anything to you as he was leaving the conference room? Was he talking to you?
Yes, he was telling me,
Okay, no, I just want to know.
okay, yes.
Okay, was he, and if you can you tell me, was he talking just close to you so only you could hear, or was he talking, how was he talking?
He was talking very loud.
Okay. So now at this point, you go into Miss Tillman's office,
Yes,
and and it's not just you in the office. Who's in the office?
Miss Tillman was sitting at her desk.
And then how is Mr. Sewell speaking to you? How is he speaking to you?
Mr. Sewell is pounding his hand and telling me what I'm not supposed to do and how I don't belong here. You wasn't supposed to speak to the parents and all of this. And I said, I don't understand.
Okay. So now at any point in time, how do you start to react to what Mr. Sewell was saying to you?
Well, I told him that I don't like the way you're talking to me, Mr. Sewell, and right now I'm gonna end this conversation because I'm gonna talk to you when you feel a little better or when you're not so angry. And I turned to go out the door.
Okay, and at that point, I'd like to introduce replay the defense exhibit, I believe is 1.
Yeah.
And we can start it from the beginning, please.
You need some water?
Yes.
The people's, one day. The people's exhibit.
Okay.
Oh, is there a pointer? May I have a pointer?
Oh.
I didn't bring one.
No, you don't have to. Did I get mine back? So when my water was closed. That's worse. Well,
May I
Mr.
approach?
Officer Krabs will come get it.
Okay, thank you. Oh, we can go to the very beginning, please. Okay, and let's stop. So in this video, do you see what you saw? No, in the video, what did you do first? What did you do first?
I walked out of the office first.
And who was following?
Mr. Sewell,
Okay,
he grabbed the door to prevent me from leaving out of the office.
all right.
And so I pulled out, walked on out of the office, and then he followed right behind me.
Okay, and then at this, and this is Mr. Sewell right here.
Yes, it is.
Okay, now at this point, I don't want to know what he's saying, but how is he saying?
He's telling me
How?
that.
Not what he
angrily-
said.
He's angrily, he's upset.
Okay,
He's yelling loudly.
all right. And what are you doing?
I turned around because I thought he was gonna hit me.
All right, understood. So then, at this point, when do you notice, or who do you notice come between or come up to this conversation?
Miss Tillman.
Ms. Tillman. Okay, so let's go, can you play it a little bit more? So let's stop. Now, can you see Ms. Tillman in
Yes,
this?
she's coming out of her office in the background.
All right, can you play it a little bit more, please? Okay, let's stop it. And can you tell me where?
Maybe you could give him the pointer.
Oh, absolutely. All right, okay, excuse me. Can you tell me where Ms. Tillman is?
Miss Tillman's here in the red sweater.
Now, at this point, while you were there, you see Ms. Tillman comes up. Do you see anybody else approaching? Not from the video, from your recollection?
No, I didn't see anybody approaching, my
Okay,
recollection.
all right. So now, the next thing you know from your recollection, what happens? From your recollection?
My
what's going
recollection,
on
Miss
here?
Tillman came in and tried to separate the two of us. She grabbed, Mr. Sewell,
Okay.
okay, and she pulled him. See, this video don't show everything.
No,
Back in this area over
listen,
here.
listen, let me help you.
Okay.
No commentary.
Okay.
Okay. Tell me okay, go ahead.
That's right. So now at this point, at any point in time, do you notice Officer Shane approaching? From
No,
your recollection?
I never saw her approach.
All right. What is the first interaction that you had with Officer Shane?
The first interaction I had with Officer Shane is she grabbed me.
So wait, stop. She grabbed you.
Yes,
So when she approached, and how did she grab you?
she grabbed me by my right shoulder.
Okay, well, hold on, just wait. Gotta get permission from
Okay.
the court. So she grabs you by your right shoulder.
Yes.
All right, can he demonstrate on security guard? How he was grabbed?
Officer Krabs, can you demonstrate on you? Okay, come in front of me so I can see them, because they're over there. Now, if you try to take them down, he's gonna take you down. Okay, go ahead.
She couldn't take me down. She grabbed me like this. And pulled me away.
So hold on. Doing it. So counsel, for the record, can you describe?
So for the record, you're saying that Officer Shane comes up to you and takes her right arm and her left arm and puts it underneath your right arm. It's sort of a hole. Is
Like a
that what
half
happened?
Nelson.
Like a half Nelson. Okay, so
All
now,
right, thank you.
thank you
Officer
very
Bryant.
much, officer. So now at that point, what do you do?
Well, I kind of like, she was pulling me
I'm
along.
kind of like, what did you
Well,
do?
she was pulling me along. She separated us. She pulled me across the room. That's what I was talking about when Tillman, they separated us. Tillman pulled Mr. Sewell into like the corridor area in front of the office, and she pulled me all the way back over here on this side of the office.
Okay, we missing some steps here. Let's.
Is he finished?
Yeah, I think so.
Finished with it?
Let's-
Okay.
Okay, come on, let's have a seat. Let's,
No,
go back up
over
here.
here, sir. Over here.
Okay, so, no, we don't share the video. Let's go see the video.
Okay.
Okay.
So now at this point, I'd like you to stop it when, just yell out, stop, when she puts you into this half Nelson as you described.
It's not in here, man.
No, okay, well, then don't yell stop, let's go.
Okay, so now when Officer Shane first approached, what did she do?
I didn't really see her. She came
No,
up
I'm just
like
wanting from your recollection, what did she do?
Yeah, I didn't see her because I didn't see her come up or anything. I didn't recognize that she came. Only one I seen was Miss Tillman.
All right, so at no point in time, did you, so you never did see her come and approach both of you? Is that your testimony?
Yes, I never seen her come in because I was trying to focus in on Mr. Sewell. I thought he's gonna hit me.
Okay, so when did this, you agree that, well, not you agree. When we look at the video, we never, did you see this half Nelson? Did you see her grab you up under the arm?
Yes,
You saw her in this video?
not in this video, no, it's not in there.
So did her grabbing, did it happen after you, at what point did it happen?
It happened, right before they escorted me out.
Play the video.
Yes, please.
I'm sorry, I'm acting like this is not I'm sorry, I shouldn't have said play the video.
No,
Also, handle your case, how you trying to handle your case.
Thank you.
I apologize. I think council did want the video.
I do want the video.
I'm sorry.
So let me see that point one more time.
Oh, here, keep it off the grass, you getting your steps in.
Thank you. Okay, please play the video and I'll tell you when to stop it. Let's stop. Okay, at this point,
Yeah.
when Officer Shane approaches, this is you, right? This is you, correct?
Yes,
And would this be at this point in time, did anyone touch you? Did anything happen at that point in time?
Officer Shay, she touched me.
What did she do?
She grabbed me.
This is when you're saying she grabbed you?
She grabbed me like right there. That's when the separation came between the two of us. Tillman pushed Mr. Sewell back into the corridor area behind him, and she pulled me across the room.
No, and when you say, this is not the time to exaggerate or anything. When you say across the room, do you mean some inches? What do you mean?
My feet, she pulled me at least 15, about 10 feet.
Oh,
About 10 feet
10 feet, she pulled you.
over there, she pulled me over there near those, the printer. That little copier right there.
Okay, where's this cop? This is the copier?
No, not that one.
Is
In
this the
left-hand
copier?
corner down there, down in the bottom corner, right there.
This is where she pulled you to?
Yes.
At what point in time did she pull you?
When they separated us, that's when she pulled me apart. I kind of went with her, but she didn't stop. She kept on coming. She kept trying to take me down. She hurt my arm. That's when I pulled away from her. And that's when she said I pushed her because she fell.
Okay, there's no questions before you at this time. Can we play the video? Can you show me where she pulls you towards this, copy machine, please? Can you play the video, do you mind?
Right.
Okay, so now let's stop it here. Do you see, now, can you identify who is this person here?
That's Miss Tillman,
And who is this person here?
Officer Shane.
Okay, and where are you?
I'm behind Mr. Dardell right there. And
Are you in here somewhere?
yeah, behind him right there. I think.
Okay, so now you would agree that there's no, so at this point, do you see her, does it look like Officer Shane is walking away?
Yes.
Judge, I'm gonna just for the record to leave.
Okay.
Borderline a little bit.
It ain't borderline,
Yes.
but it's the same.
Yes,
Okay.
absolutely, okay.
Okay.
Continue to play the tape, please. Okay, let's stop it there. Do you know where you are at this point?
I'm leaving out.
You're leaving out.
Yeah, they told me to get your things and leave.
And who is this person here?
Officer Shane.
Now, you mentioned earlier that there was a point where she grabbed you in this half, Nelson. Had it occurred at any part that you saw?
It didn't occur in the video, but it occurred.
So, and it's, okay. And, okay. And at that point you left?
Yeah, I went up to the classroom, got my things, and was escorted out by Officer Rowland and Green and Mr. Dardell.
So at the first, you did testify earlier that Officer Shane did touch you at
Yes.
part of the video.
Yes, she did.
And at that part, when she did touch you, what did you do?
I kind of jerked away because I didn't know, I didn't see her come up. I didn't know it was her. So, you know, it was a natural reaction for me to jerk because I didn't know it was her.
Okay, all right, very good. So now let's see, did you and Miss Officer Shane have any previous interactions, negative interactions in your mind?
Yes.
And how far away, how close to this incident did they occur?
Maybe about, I don't know, probably about 3 weeks prior to this, or maybe even, well, there's a couple incidents. She comes into the,
No.
the last one.
The question is, what's the distance in time before
A couple of weeks, 3 weeks.
before
I
this
said about
incident?
2 or 3 weeks. before
Okay.
that one.
And then council follow up if you have one.
Okay, thank you. And in that instance, what was Officer Shane's demeanor towards you?
She was in the conference room, and she was interrogating me. She always asked me, "What do you mean by this? What do you mean?" When I answer the question, she always goes,
Sustained.
So when you're describing, I mean, so when you just said something that she said, I'm not asking what she said, I want to know what her demeanor was towards you.
Are you finished with the video at this
Yes,
time?
I'm absolutely done.
"She's talking at me. She's talking at me
Okay.
aggressively."
And aggressive, and that's how you perceived it.
Yes,
All right, understood. And that was about 2 to 3 weeks prior to.
yes.
Did you have anything against Officer Shane on December 16, 2019?
No, not at all.
Okay. And then at this point in time, when you and Mr. Sewell was having this discussion between the two of you, did you seek Officer Shane's help? Did you ask for her help in any way?
No,
Did you hear anyone else ask for her help in any way?
no.
And now, as a result of all this, what, are you still with Central High School?
No, I'm not.
Okay, very good. I don't have any further questions, thank you. Oh, no, wait, you got a question.
I'm sorry.
Did you shove Officer Shane?
No,
Did you push your hand away?
I don't recall if I did or not, but if I did it, it was just out of the altercation. I never meant any, harm to Officer Shane.
Okay, but when you talked about, when I asked you earlier, you said you sort of jerked your hand away. So, was that, what was that?
That was the reaction. I was jerking away from the reaction. That was just a reaction.
Okay,
Because
now,
they were seemed like they were trying to jump on me.
okay, and that was a reaction to what?
If they're trying to,
Not they, a reaction to what? To who?
Officer Shane,
Doing what to you?
grab me.
Okay, thank you. No further questions.
Okay, I'm gonna take a break. So I'm gonna take a break from this case. Just briefly, and well, do you all wanna go ahead and take the lunch break? Why are you shaking your head? No, you're not getting ready to take a lunch break because we have two sentencing.
Oh.
But, we have to take a lunch break. Do you have any other witnesses?
I have no other witnesses, Your Honor.
Oh, we don't have to take a lunch break. Look at my, let's stay up this, they like, no, let's head along through, Judge, we want to leave. Okay, well then, let's do this. Are you in agreement with those head shakes, Mr. Brother?
Yes, I'm fine with
Okay. Okay, because I mean, they was some aggressive head shakes. We're gonna take a break from this case. I have two sentencings. And then, so this case can come back at 12:30. We'll come back at 12:30. 12:35. Come back at 12:35 because I want to try to take a little break in between the two sentences. All right. Go ahead and talk to the people. Oh, this. Yes. You might be kind of recording something. Okay. Mr. Oh, he's not even connected. Okay, Mr. Bachman isn't connected, so come on in, Mr. Jefferson.
How you doing, Judge? How you doing?
Wonderful. All right, Mr. Patterson, you can turn your video off until your lawyer gets connected, and then I'll let you know you can turn your video back on. Your lawyer is still floating. He's not connected. So I'm gonna take another sentencing, and then if Mr. Bachman hasn't connected yet, we'll call him so he can connect. All right. I'm ready on. Arnold. Right. This is case number 214443401, the people of the state of Michigan versus Camry Amanda Arnold. The defendant is charged with operating while visibly impaired. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Brown, on behalf of the people.
Good morning, Your Honor. I'm Thomasine Jefferson on behalf of Camry Amanda Arnold.
Ms. Jefferson, your P.O.
42872.
Thank you. All right, today is the day set for sentencing. I have had an opportunity to review the pre-sentence report. With respect to the report, are there any additions, deletions, or corrections on behalf of the people?
None on behalf of the people, Judge.
Any additions, deletions, or corrections on behalf of the defense?
Not on behalf of the defense, Your Honor.
Anything with respect to sentencing on behalf of the people?
Yes, Your Honor, very briefly. So, Your Honor, the plea agreement was to reduce the original charge operating while intoxicated to operating while visibly impaired. I do see there's a recommendation from probation for 12 months probation, with terms and conditions. Your Honor, the people have no objection to the recommendation. We actually asked the court to adopt, probation's recommendation. It looks like there is one, prior criminal history, however, it was adjudicated under higher judge, so at this time, the people are asking for to adopt their recommendation.
And on behalf of Ms. Arnold?
Yes, Your Honor, just want to point out to the court that Ms. Arnold does have one daughter. Ms. Arnold, is employed and she doesn't get any physical, she doesn't get any financial assistance in supporting her daughter. So she is a single mom. Ms. Arnold is sorry for what happened. We want to point out to the court that this did happen, I believe, back in 2020, during the era of COVID. Ms. Arnold has not been drinking since that time, consuming any alcohol or anything like that. I don't believe there was a sentence agreement, so we are asking the court to consider a 6-month term of probation. And to take in mind that Ms. Arnold does not get any, she don't get aid. She don't get any type of aid, so we ask the court to take that into consideration and assess the advice and cost. Thank you.
Would Ms. Arnold like to make any statement on her own behalf?
I just want to apologize for.
I'm sorry, I couldn't come over to the mic a little bit.
I said, I just wanted to apologize for anything I wouldn't want for us to have to be here ever again, or for me or anyone else. I tried to do what I thought was necessary at the time, but it was one bad decision that cost me 3 years. I feel like even my daughter 3 years, we've been held back so many times. Just trying to seek employment opportunities.
All right. Okay, the court is ready to impose sentence. I will do so as follows. I am going to accept the recommendation from probation for a probationary period, and I am going to accept the recommendation for a 12-month probationary period. Of course, Ms. Arnold will be eligible for discharge after 6 months. So I will set a 6-month review date, and we'll set that 6-month review date for April the 18th. At 10 a.m. Final review, October the 18th. So if we get to the final review, then the date is October the 18th. The court is going to impose the mandatory cost of $210. Oh, I'm sorry, I'm getting ahead of myself. The terms and conditions of the probation are as follows. You shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without consent from the court, and you must make a truthful report to probation on a monthly basis. The court is going to impose mandatory costs of $210. And then, counsel, are you asking me to reduce her of additional costs, or are you asking me for community service in place of the cost? Because there's not much reduction I can do.
Ms. Arnold, we'll ask the court that leave at the court's discretion. She could do community service, she indicated.
All right, the court is going to, in lieu of the additional fines and costs, impose let me add it up and see what it adds. So the court is going to impose, I would have imposed a $300 fine, oversight fees of $420. However, at the halfway point, it would only be $210, and then a $100 substance abuse evaluation, and pre-sentence investigation fee. For those costs, the court will convert that to community service, and then I'll only convert $210 of the supervision fee. That will leave a balance of $210 on the supervision fee. However, if she finishes at the halfway point, then that gets waived. If she doesn't, then I can convert that if it needs to be converted. So I'm gonna convert 300, 5, 10, 16, $610 to 61 hours of community service. And then she does have to pay the mandatory cost of $210. Additionally, I am gonna order that she submit to random urinalysis once a month, due to the nature of the charge. That is an additional, fee of $60. That's $10 per test. So I'm adding $60. If she finishes at the halfway point, then again, I won't add in another $60. So I'm only adding 6 months worth of urinalysis fees, and that is if she tests at the court. If they approve for her to test outside the court, that $60 goes away and she has to pay the other agency directly. If she tests here, it's $10. If she goes somewhere else, it's whatever their fee is. Okay. So the total, that she will owe is $270, and then she's gonna do 61 hours of community service. Additionally, you shall not use or possess any illegal substance. You cannot use or possess any marijuana without a valid medical marijuana card. You cannot use or possess any opiates without a valid prescription and letter of explanation from the doctor. You cannot consume any alcoholic beverage or alcohol in any form. You cannot drive without a valid driver's license. According to the report, I think you do have, yes. Well, you have a restricted license, so whatever your restrictions are, you have to go according to those restrictions. You must attend the victims impact panel and watch the consequences video. Those are both virtual. You will attend the driver's improvement program, pay any outstanding tickets that you have. According to this, you don't have any. I do want you, because of your age, to provide proof of your education. So according to this, you have completed a high school diploma and you have some post-high school certificates. So those post-high school certificates, if you have them, will suffice in terms of proving that you have a high school diploma. But if you just have a copy of your high school diploma, then I want you to provide proof that you did complete at least high school. Otherwise, I will order that you participate in an adult education program. I think that's it. Those are one of the- I'm not going to order the mental health evaluation. And yeah, that's the court's order. Okay, so we are in the middle of a trial, and so we are still going to mail you a copy of the order, because the clerk is going to do it at the end of the docket. We'll mail you a copy of the order to the Oak Lane address. That's your address. And then probation will contact you at the phone number ending in 6063. Okay. I appreciate your apology, and it's not even just for, it's not, I'm glad that you recognize that that was just not a good decision to make. And especially now that you know, the fact that you have your own children. I've never been the victim of, thank goodness, of any type of drunk driving. Sometimes people think I have because of, I'm so passionate about it. But I would never want my children, I would never want to lose my children or myself or, just any person because somebody else chose to drink. We can drink as much as we want to drink at our homes. And then, once we're out in public, or you could drink to a certain degree, because you might get charged with public drunkenness. That's what they had somebody charged the other day. So a certain degree, you can drink as much as you want out in public, as long as you have a ride, you know, someone is bringing you. So that's very important. That's very important. And when you view the consequences video and you, view the victims impact panel, I think you'll even have a greater understanding of how your decision could have impacted other people's lives so negatively. But you're gonna be all set, and I think you're gonna probably get discharged at the halfway point, so just, you know, put in the work, and then I'll see you, in 6 months, okay?
Thank you so much.
All right, you're welcome, have a great day, stay safe.
Take care. Bye-bye.
All right. Okay, Mr. Bachman, I'm ready, you can start your video, Mr. Patterson, you can start your video.
Good morning, Your Honor.
It's filming.
Well, afternoon.
I say start your video, but I'm doing, Mr. Bachman, you too busy for me, come on now. Yes, I want Mr. Bachman's undivided attention. All right. What did I do with the precinct report for Mr. Patterson? Oh, you're all right. It's not, you are so correct. I could have been there, Mr. Patterson. Okay. Why did I make this sentencing? Because it's mixed in with all the sentencing. Do y'all see Miss Ritter over there, like she tired in the court? Okay, thank you all. It's not a sentencing. I promise you, I thought it was. But this is case number 22455-9301, the people of the state of Michigan versus Amin Ra Patterson. Defendant is charged with 1 count of weapons. What is this charge? Purchasing without a license?
No, carrying concealed weapon under the influence.
Carrying concealed weapon under the influence. I wanted to show up on the docket correctly. But today is the day set not for sentencing, but for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
May it please the court, Your Honor, Harry Boffman, P55052. Happy Friday. Mr. Patterson, state your name for the record, full name.
Amin Ra Patterson.
All right, today is the day set for final pretrial conference. How are we proceeding?
Well, I'm pleased to announce the defendant is going to here and now waive his right to any further trials or hearings. He's going to plead guilty pursuant to a recommendation that he would plead guilty to CCW under the influence with a blood alcohol level of 0.08 to 1.03.
Is that still a misdemeanor?
It is, Judge, and it's carrying concealed weapon under influence with a BAC of 0.08, but no more than 0.10.
Okay, Mr. Patterson, is it your intention to accept the people's offer and enter a plea today?
Yes, Your Honor.
All right. Mr. Patterson, I'm going to share my screen, and when I share my screen, on the screen, you're going to see an advice of rights form. My question to you, Mr. Patterson, is have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes, I have.
Sir, when you did that, did you understand your constitutional rights?
Yes, I do, ma'am.
Do you understand this is a misdemeanor and therefore you have a right to a trial? However, if I accept this plea from you today, you are giving up your right to a trial?
Yes.
Sir, has anyone threatened you in any way or promised you anything that was not placed on the record to get you to enter into this plea?
No, ma'am. No, Your Honor.
Are you currently on probation or parole?
Yes.
Drawing your attention to number 8 on the advice of rights form. Do you understand that if I accept this plea from you today, that it may be a violation of your probation or parole?
Yes, Your Honor.
Are you sure?
Yes.
With that understanding,
Your Honor, may I, and forgive me for interrupting, I just want to give life to what appears to be the defendant's reticent. He is currently on probation or parole for an event that this comes out of the same transaction or occurrence as the instant case. And I don't believe it would qualify for as a violation of that particular probation. Okay, Mr. Patterson?
Yes.
Yes. What y'all saying?
So to clarify, Judge, this is the incident where the city took the OWI.
Oh, yes. Okay, thank you. Okay, I do remember. Okay. All right, and with that understanding, do you still want to enter into this plea?
Yes, Your Honor.
Finally, drawing your attention to number 11 on the advice of rights form. It indicates that an appeal, why am I thinking not working? That an appeal to the circuit court may be taken within 21 days of the date of your sentence. Do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would have to request permission of this court to set aside the plea or request permission of the circuit court to appeal the conviction. Do you understand?
Yes, Your Honor.
With that understanding, do you still want to enter into this plea?
Yes.
Raise your right hand for me, please. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Who's going to voir dire Mr. Patterson with respect to the factual basis? You can put your hand down.
Could you repeat the question, the last question?
Judge, I can, if that's okay with the court, Mr. Bachman.
What happened to Mr. Baldwin? Mr. Baldwin disappeared. Okay. He's trying to log back in. What is it?
Okay, so Judge, I thought, well, I do have Miss Tanisha's building. And I know when I was last here in the court gave me today's date for the sentencing. But of course, now that I'm looking closely at the pre-sentence investigation report, it says the sentencing date is Monday, not today. I don't know if the court will consider doing it today, though Miss Building is not dressed properly.
Oh, well, no, I ain't gonna do it. She's not dressed properly, but plus I'm still in trial.
Okay.
But I don't remember giving you today, but if I did, I don't know how I didn't make the docket for today. If it's on the docket for Monday, I haven't even reviewed the pre-sentence report.
Okay, because I know this is, it will have been, well, Monday will be Miss Building's third time coming, but, okay, Judge.
Okay, well, but if she came twice, somebody should have told her when she come the third time to dress correctly.
She never came before. She
Oh.
was always issues with the not making it to probation.
Oh, well then this her first time on, maybe.
It's my
Okay.
third time, I guess I'll say.
Right, oh, yeah, probably your third time, but she got dressed correctly, I'm not gonna make any, I'm not gonna accommodate her if she's not dressed properly, because she can't come in. What's the issue with her dress code?
Ripped jeans, tank top.
Oh, no, she can't come, tell her don't even show up for sentencing looking like that, though, come in your Sunday dress, Sunday clothes, when you want the judge to sentence you.
Okay, thank you, Judge.
Okay. Or, I mean, I don't know, maybe her Sunday clothes is, just come in business casual, if you, don't come like that, okay.
Thank you, Judge.
Mr. Bachman, you disappeared, what point did he disappear?
We were making a factual basis.
Okay, yes, all right, and were you okay with Miss Ritter? Putting the factual, voir dire, or did you want to voir dire your own client?
I would like Ms. Ritter to voir dire the client, please, and thank you, Ms. Ritter.
All right, Ms. Ritter.
Thank you. Mr. Patterson, I want to take you back to August 2nd of 2022. Were you in the city of Detroit?
Yes.
And were you operating a vehicle on 20000 Evergreen?
Yes.
And is that the county of Wayne?
Yes.
And prior to operating that motor vehicle, did you consume any alcohol?
Yes.
And when you operated that motor vehicle, were you still under the influence of the alcohol?
Yes.
And did you have a pistol on your person or in the car while you were operating the motor vehicle?
Yes. It was locked
Just-
up.
No, did you have a pistol in the car?
Yes.
Judge, the people stipulated to the blood alcohol content of 0.18, with that the people are satisfied.
Your Honor, I stipulate to the blood alcohol level as well. I'm satisfied with the factual basis. Thank you.
All right, then the court will accept, the court will receive the stipulation and accept the plea to, the amended charge. I have a question. When he was sentenced on the other case, did they do a pre-sentence investigation?
Yes, that was already completed, Your Honor. I'm asking for immediate sentence here. The defendant is already on probation.
I can't do immediate sentencing because I haven't had an opportunity to read that pre-sentence report. But what, I can tell you what I want, I do want, I want that pre-sentence report from his other case. Does anybody have the case number?
I have the.
I do.
Yeah, it should be a Z ticket maybe. Okay,
I
what's
have-
that Z?
Z808731.
Z8087.
321.
321.
Correct.
Okay, so who was the judge? Okay, so can you just contact probation and ask them to forward to us a copy of that pre-sentence report?
Yes.
I also, if you could get from Judge Garrett, Ruth Garrett's clerk or somebody, the actual probation order, also. So I will, because he's on probation for the OWI portion, so I will definitely look at his conditions in that case, look at the pre-sentence report and sentence him accordingly. When did his probation start? Is it like a new probation?
Yes, Your Honor. The defendant, I believe, he just started on probation in August. I'm checking.
Okay, so they'll definitely run together.
Mhm.
And then I'll look at her conditions and see if there's anything I need to add to his probation. So they'll run concurrently. And other than the mandatory cost and a fine probably on this particular charge, they might be almost identical. So let's set the sentencing. I don't need to set it far out because we'll have those things. So maybe we can set it for November 15th. How many do I have? A lot. How many overworking myself? Oh, that I am overworking you. Okay, well, it's Treasure on it.
2 sentencing, 18 pre-trials, 7 final pre-trials.
That don't add up with what that don't add up with my little tick marks I got on here. Print me that docket for, print me that. Okay, looks like I need to go to a different day. Yeah, 15. But what about, let's look at, what about the 9th?
One try.
Yeah, that ain't going.
Okay, then,
I have 2 sentencing, but so,
it was like 21 cases.
Mr. Bachman, are you available on the 9th of November?
I'm checking now, Your Honor. I am available on that date. Thank you.
All right, let's do the sentencing on the 9th of November, and then all I need is the PSI from the other case and the probation order from the other case, and then we should be able to fashion a sentence that, is, fair. All right, Oh, 9 o'clock. 9 o'clock. All
Anna,
right,
would you,
anything-
forgive me, would you allow me to appear in person on that date? I see that I'm gonna be in the district court in person on another matter.
Oh, yeah, you can always appear in person.
Perfect.
Even though one day somebody locked out, Mr. Bazey, he was in the hall, in the stairwell on court, and then I said, I thought he was across the street, then he said, no, they wouldn't let him in. That would never happen again. I don't know who that was, that one Officer Brown, he's shaking his head, no, like, that wasn't me, Judge.
I never even heard about it.
So you can always come in person, the court is open for business. Now, I might not be in person, I think I will be that day, but, you can come in person.
Okay,
All
thank
right.
you.
Then we're all set until November 9th at 9 o'clock. Have a great day, stay safe.
Have a great day to you and your staff, everyone. Have a good
Thank
week.
you.
Bye.
You're welcome. Whoops. Okay, I don't really need a break. Does anybody need a quick break before we finish trial? Oh, Ms. Ritter. I'm ready. Oh, no, I don't have to say. That's for this case.
For, patent.
I mean, yeah, just put that in the file. Put it in the file.
You can come up right now.
Where's his lawyer? Oh, okay, yes. You can come back and take the stand again. You can put your coat back in your chair.
Okay.
All right, and then thank you, for your patience during that interruption. And I believe the defense had finished his questioning, so okay. Ms. Ritter, you. I wrote on the wrong page. Ms. Ritter, you may proceed.
Thank you, Judge. Good afternoon, Mr. Morris.
How you doing?
So, Mr. Morris, I'm gonna ask you some questions, and if you don't understand my questions or you need me to repeat a question, just let me know, okay?
Okay.
So, Mr. Morris, I'm just gonna cut straight to the chase. You testified with Ms. Cox that, actually you testified and demonstrated that Officer Shane put you in a full Nelson and pulled you about 10 feet across the office, is that correct?
Yes,
And you watched the video in court, correct?
yes,
You watched it a few times, correct?
yes.
And nowhere, in that video did you tell, Ms. Cox to stop the video so you could point out where, Ms. Officer Shane dragged you from your shoulder across the office, is that correct?
No, that's not correct. I said that, I was grabbed. At one point I was grabbed.
Can you listen to the question? She said, restate your question.
Mr. Morris, my question was, during the time Ms. Cox played the video, you did not tell her to stop the video at any point to point out where you were dragged, according to your testimony, correct?
Correct.
Okay, and you will agree that nowhere in that video, during that video, how many times it was played in court, that Officer Shane grabbed you in his full Nelson and dragged you across the office, is that correct?
Can you say that again?
Nowhere in the video that was played, did you observe Officer Shane grab you on your shoulder and drag you across the office, correct?
No, not in the video.
Okay, and you testified she did that when?
12/16/2019.
I'm sorry, let me rephrase my question. You testified that she grabbed him with full Nelson.
Objection, that's a mischaracterization. He specifically testified to a half Nelson.
She's correct.
I'm sorry, Judge, let me rephrase my question. This half Nelson that you described to the court, you testified that she did that after the fact, after the incident?
After what incident?
When you and Mr. Sewell were arguing and she came in between you two?
Well, at some point in time, after the argument, yes, she grabbed me.
So when after the argument did she grab you and put you in a half Nelson?
It was immediately, as soon as we came out of the office, when I turned around and butted him up, when she ran over, it didn't show it in the camera or the video, but, she grabbed me and pulled me across the room, and Ms. Tillman took Mr. Sewell back into the other area, and it's not on the video.
Okay, Judge, may I share the screen?
You may.
So, Mr. Morris, can you see the screen from where you are?
Yes,
Okay. Can you see?
yes,
Okay, so I'm gonna play the video from the beginning, okay?
okay.
And I want you to indicate where on the video did Officer Shane grab you in a half Nelson, attempt to grab you in a half Nelson, anything of that nature. I want you to point that out to me when I play the video, okay? Okay, Mr. Morris?
Yes,
For the record, Your Honor, the people are playing the video at 0 minutes and 0 seconds. And the people are stopping the video at 10 seconds. Do you see yourself, Mr. Morris?
yes, I do.
Okay, where do you see yourself in the video?
I'm in front of Mr. Sewell outside of Ms. Tillman's office.
Okay.
It should be right there because that's where they separated us.
The people stopped the video at 20 seconds. Okay, so when you say they separated us, who are you referring to?
Ms. Tillman grabbed, Mr. Sewell and Officer Shane grabbed me.
Okay, and you're saying that's when she put you in this half Nelson?
Yes,
But you testified in Ms. Cox, when she put you in a half Nelson, she dragged you from where the office is located to the printer, correct?
yes, she pulled me across the room, yes.
Okay, in that video, did she?
No, it's not in the video.
It's not in the video?
No,
And you testified that this is the video that was in the office on that day, correct?
Objection, and objection as to, there was never his, testimony that this was the video.
Lack of foundation.
Lack of foundation, yes, objection.
I was afraid to.
Yes, please. So the objection is sustained.
You viewed the video, Mr. Morris, correct?
yes,
And you testified that you see yourself in the video, correct?
yes,
And would you testify that this is a fair and accurate depiction of the video that's inside the office on the day of the incident?
well, I wouldn't testify to that because that's, I mean, it's, you don't see me coming in or leaving.
No. I need you to,
No,
answer the question.
okay, no, Your Honor.
Okay. Judge, the people are gonna stop sharing the video. So you're testifying that it's not a fair and accurate depiction of what took place on that day?
Yes,
Okay. And, do you recall giving a statement to the police on the day of the incident, Mr. Morris?
no,
You don't recall?
I didn't make a statement the day of the incident.
You did not make a statement.
No, they sent me home,
So you never talked to the police on that day?
not on that day.
Did you ever talk to the police after the incident?
Yes, I went to Officer Toole, the investigator.
Okay, do you recall what day you made a statement?
I recall I made that statement on, it was the next day, would have been the 17th.
Okay, so you made a statement the next day after the incident?
Yeah, I went to the police station and made a statement.
Okay, and you recall signing that statement?
I wrote it.
You wrote,
Sir, do you recall signing the statement?
Yes,
Okay, next question.
thank you. And you would agree that the day after the incident, your memory was, more fresh than it is today, correct?
No, I don't agree with that.
You don't agree?
Mhm.
So you're saying that your memory was not more fresh than it is today testifying in court?
My memory is still the same. This is vivid in my mind.
It's vivid in your mind today and the day after when you made the statement, correct?
Yeah.
Okay. And in that statement that you made to the police, did you tell them that Officer Shane put you in the Pat Nelson?
Yeah, I told him to grab me and hurt my shoulder. Yes, it's in the statement.
Judge, may I approach?
You may.
Yeah, okay.
So, Mr. Morris, I just handed you a copy of that statement. I want you to review that, and when you're done, look up and tell me, and where in that statement did you tell Investigator Tools what happened on that day as far as the half Nelson?
Well, this is my rebuttal.
So here's the thing. It is so helpful to the court if you answer a question that is being asked of you.
Okay.
So here are the instructions. She said, review the statement and then let her know where in the statement, you talk about the half Nelson.
Okay. Can you repeat the question? You said after I read this statement, then
Can you tell me where in the statement did you tell the officer did you tell Investigator Tools that Officer Shane put you in the half Nelson and dragged you across the wall?
it says at the top here, it says, did Officer Shane touch you? She grabbed my right arm and myself, and Mom Sewell was nose to nose. I thought he was going to hit me.
Okay, so where in there did you tell Investigator Tools that you were in a half Nelson and dragged across the office?
No, I said she grabbed me by my arm.
That's not my question. Where in what you just read to the court?
It's not in here.
Thank you. May I approach Judge?
You may.
So it's true that you didn't tell Investigator Tools that you were put in a half Nelson and dragged across the office, correct?
No, I didn't tell him to have Nelson because I
It's
just
yes or
got
no,
my
Mr.
shoulder.
Morris. It's yes or no. It's true that in that statement, you did not tell Investigator Tools that you were putting a half Nelson and dragged across the office. Yes or no?
No, I didn't say I was putting a half
Okay,
Nelson.
thank you. May I have a moment, Judge?
You may.
And Mr. Morris, your testimony is that this is the statement that you made to the police the day after the incident, correct?
I don't remember that particular statement and stuff you have there.
So you don't remember this, you don't remember making a statement?
I made a statement, but he filled that out. Officer Tool.
Judge, may I approach?
You may.
My rebuttal.
I just handed you the statement again, Mr. Morris. And after reviewing the statement, just look up.
Okay.
So did you see your signature on that statement?
Yes, it's on here.
And so you had a chance to review those questions after they were asked and they answered, and you signed that statement, correct?
No, I didn't have a chance to review these.
So you signed the statement and you didn't look over the content of what that statement was? Yes or no?
I signed these papers, but I don't recall me seeing all of this.
Sir, the question is,
I signed it.
did you have an opportunity
To look at them.
to, are you gonna be the judge right now or am I? Okay, the question is, have you had an opportunity to review, or did you have an opportunity to review the statement before you signed it? That was the question.
Is that a yes or no, Mr. Moore?
I reviewed it, I signed it.
Okay, may I approach Judge?
You may.
And it's your testimony, Mr. Moore, that your memory is vivid today and the day after the incident, correct?
Yes,
No further questions, Your Honor.
Can you redirect?
Yes. Mr. Morris, when you describe, can you tell me what a half Nelson is? What happens in a half Nelson?
it's sort of like I guess it's a wrestling hold or whatever. And I was just describing the way she grabbed me to the court and we demonstrated with the officer. That was all. Not that it was my testimony. I testified to Officer Jewell that he grabbed me.
No, well, my response to that is, it's not. He was explaining as to how he was explaining to the court.
No, let me tell you what your client just said.
What did he just say?
He said, I was just showing the judge, what a half Nelson is, but that wasn't my testimony. So I'm confused by that statement completely.
Don't you say a word.
I beg your pardon?
Yes. Okay.
You may proceed. The objection is sustained as to non-responsive apparent.
Thank you. Mr. Morris. Earlier, when you were describing what Officer Shane did to you, is that the same thing that you described to the officer on December 17th, 2019?
Yes.
And at that point, do you also recall stating, and you also recall what you did when she touched you? Do you recall that?
Yes.
And what did you do? What did you tell the officer on 12/17 that you did when Officer Shane touched you? Do you need to look at your statement to refresh your recollection?
Yeah, well, I guess I kind of pulled away because I pushed Sewell off of me because he was up on me and I thought she was grabbing me so he could hit me. So I pulled away a little bit from her. I guess that's what, because I didn't see who it was. I just pulled away and I pushed Mr. Sewell off.
All right. So then, is there anything different? And after every one of your questions, you actually initialed. Do you recall initialing?
I don't recall that.
What do you need to see this in order to
Yeah, let me
refresh
see.
your? Okay, Your Honor, may I approach the witness?
You may.
Thank you.
Yes, I was at. Yes. Yeah.
Sir, please be quiet. Read to yourself and then.
I'm sorry. Yeah, I see it.
So my question is, when you gave this statement, did you initial each answer?
Yes.
Does that, so when you were asked, when you testified earlier, do you take back, or are you changing your testimony that Officer Shane grabbed your right arm?
No,
So on that day, what did she do to you?
she grabbed me with my right arm, shoulder.
And the way that you say she grabbed you, that's similar to what?
It's similar to us, I have Nelson.
All right. So when you discussed earlier when you testified, is there anything that happened on the 17th that you're saying that did not happen? Are you changing your testimony in any way?
No.
Thank you. No further questions.
All right, I have a question. Sir, you testified, that Officer, Shane grabbed your arm and pulled you across the room by the printer. Is that your testimony?
Yes.
How long did that take her? How long did that take?
Maybe 5, 6 seconds.
What were the other people doing when Officer Shane grabbed you by your arm, pulled you across the room?
Which people?
The other people.
Okay. Ms. Tillman grabbed Mr. Sewell and pushed her over against the wall here. She was pulling me over here. The rest of it was kind of like just standing around in the hall.
Okay. How did you, after you were pulled over by the printer, where did you go next?
I went to go out, start going toward the exit.
Where did you go next? How did you go? Did you go back over to Ms. Tillman's office and then go out? Did you go straight down,
I ran around the table and out to the front of like the lobby area.
Okay, play the video.
Play from the beginning, Your Honor.
Might as well, because it moves around too quickly to play it. Stop. How did you get back over there? Officer Krabs, do you have a pointer? Point to the man in the light blue shirt. Now the man behind the man in the light blue shirt. No, I'm sorry, in front of the man in the light blue shirt.
Right here?
Right, is a man directly right there. Is that you?
That's me.
Okay. Right here, is this before or after Officer Shane drug you over there? Officer Krabs, you see that printer down in the bottom right-hand corner, left-hand corner? Right. Is that frame that I'm looking at before or after Officer Shane drug you down there to that printer?
I think it's before.
All right, then play. Now stop. Rewind like 3 seconds. Okay. Officer Krabs, there's a lady in a beige sweater, and then there's a lady walking past the lady in a beige sweater. Point to the lady walking past the lady in the beige sweater. Who is that?
Officer Shane.
Okay. Play. Stop. Did you see Officer Shane walk past that printer?
Mm-hmm.
Okay. Is that a yes?
Yes.
Okay. Did she pull you by that printer before or after she just walked past that printer?
I think it's before.
She pulled you by the printer before. So rewind.
So where is it?
I don't know. Just rewind. All right. Play. So in between you being, keep playing. In between you being down here in front of the man in the blue and Officer Shane walking right here, she drug you by the printer?
Yeah.
So what happened? Where is that? What happened to it?
What happened to it?
How did you get over there? So rewind like 3 seconds. I asked you, I said, how did you get out? Rewind again, rewind. Let me talk right now. Hold on, rewind. Like right there, yeah. Okay, you over there, she backs up, stop. You don't be Johnny on the spot, but stop. Oh. How, when, where, how did you get back over there? Officer Kraft, point in front of the man in the blue shirt, light blue shirt. Is that you?
Yes.
How did you get there? You don't know.
I don't know from this video, I just.
All right, okay. Any questions based on my question?
No, thank you.
Any question, counsel, based on my question?
No, thank you.
All right. You may step down, sir. Anything further on behalf of the defense?
No, defense.
All right. Any rebuttal on behalf of the people? Court is ready to entertain closing argument on behalf of the people.
Yes, Judge.
Hold on, let me give it. All right, counsel, you may proceed.
Thank you, Your Honor. Your Honor, so this trial actually started on Thursday, October 12th. And the people at that time called Officer Shane to the stand. Officer Shane testified that on or about December 16th of 2019, she was employed as a DPS officer at Central High School in the city of Detroit. Officer Shane testified that there was some conference going on in the main office area involving 2 students. She testified that during that conference, there was a discussion between Mr. Sewell, who was the principal of Central High School, and Mr. Morris, who was a teacher's aide, as I would refer, in the office having a discussion about an incident. Officer Shane testified that there was an argument that ensued, and the argument escalated to the point where there were loud voices in the office. And the testimony from Officer Shane is that she came out to see what was going on between the 2 parties. As she got in between the 2 parties, Officer Shane testified that Mr. Morris pushed her. I think her testimony was twice. And after that, Mr. Morris was then in the office for a little while before he left and officers came to the high school. There was also testimony taken from the assistant principal, Ms. Deshina Tillman, and Ms. Tillman testified to the court basically that there was an argument between Mr. Sewell and Mr. Morris that was so loud that she came out of her office to see what was going on. As she stood close near where the argument ensued, she testified that Officer Shane approached. Officer Shane tried to insert herself in between Mr. Sewell and Mr. Morris, putting her hands up, and doing so, she testified, Ms. Tillman testified that she observed Mr. Morris slap Officer Shane's hand so hard that her hand blew back. Today, Your Honor, the people called the 3rd eyewitness, Mr. Marlon McDowell, to the stand. Mr. McDowell testified that, again, there was an argument between Mr. Sewell and Mr. Morris. Mr. McDowell testified that as he perceived the argument between the 2, he saw Officer Shane approach Mr. Morris and Mr. Sewell, and while Officer Shane had her hands up, this was Mr. McDowell's testimony, she had her hands up between Mr. Sewell and Mr. Morris, and that's when Mr. Morris pushed her hand away. Now, Judge, there was a testimony given from these 3 witnesses, and the people do understand that during opening, the people told the court that there was consistency within these testimonies. And during closing today, the people are going to testify, or I'm sorry, the people are going to point out to the court that the testimony, again, was consistent with what all 3 of the witnesses said. Now, Judge, I want to point out that the people did not tell the court that these testimonies will be perfect. These testimonies will be completely 100% a match to each testimony. Why? Because this did happen in 2019, Your Honor. This happened in 2019, and the witnesses that the people called to the stand all had different views on that day of the incident of what have occurred, and they all had different perceptions on that day of the incident as to what has occurred. However, Your Honor, the people still stand that there was consistency in the testimony as to Mr. Morris having this argument with the principal, Officer Shane approaching the situation to try to intervene and de-escalate the situation, and there was some type of offensive touching, whether it was a slap of the hand, a push of Officer Shane, or a slap of the hand so hard that it pushed her hand back. The testimony still meets the people's burden that there was a forceful or violent or offensive touching of the complaining witness, Your Honor. The people also admitted People's Exhibit 1, the video. And the video, the people do admit, Judge, it wasn't the best quality. However, the video, again, is consistent evidence for what each witness has testified as to what happened on this day at the high school. Your Honor, the court taking that into consideration, I want the court to pay attention to the testimony of to the complaining witness in each testimony and each witness as to what happened on that day, Your Honor. That is important because, again, there is consistency as to the events and what led up to this incident and what occurred during that incident between Officer Shane and Mr. Morris. If the court takes that into consideration, Judge, plus the video that was played several times in court, the people are sure that the court will find Mr. Morris guilty of count 1, assault and battery.
All right, on behalf of the defense.
Yes. Your Honor, I'm gonna start off the same way I started off with my opening, which is my prayer to this court is that the court comes back with a not guilty. Now I'll say, I didn't see a half Nelson. I didn't see a shove. I didn't see that. I don't know where any of this is. But what I did see was a officer, and this is Officer Shane, come up. I guess that's doing her job. She saw a situation, she was coming to it. I did see a situation where there were two men in front of one another. I did see Miss Tillman. I did see my client's hand go back. I did see Officer Shane going forward. I did see them telling her to go, not telling her to go back, but she was going backwards towards the printer. I did not see this drug. I didn't see that. But what I did see is consistent with, I didn't see a shove of the chest. I didn't see that. I didn't see that twice. Didn't see that whatsoever. And the people who were the closest didn't see this push of the shove of the chest by my client towards Officer Shane either. They didn't testify to that. They testified to this hand. Now, what makes sense to me, and this is self-defense. Somebody comes up to you, touching you, and you're like, hey, get off me. That's self-defense. That is a situation where my client is trying to focus on this man-to-man. Looks like it might go into combat. He's not quite sure. He testified to that. He thought this man was going to hit him. And then somebody comes up to him, and he says, grab his arm. Now, I see his arm go back, which is consistent with somebody coming up grabbing you and you're trying to get them off of you. That's it. We don't see her pummel her whatsoever. We don't see this. And yes, it was consistent in the sense that the testimony was consistent in the sense that Tillman, McDowell, all say they did not see this shove. Tillman, McDowell saw my client yank away. And if your hand is where my hand, if you touch me and all of a sudden I yank away and my hand goes back with a force, that's the way it goes back. Who took the initial stance? That was Officer Shane. Did she touch both of them? No, she touches my client. And my client says, grab by the arm. We go by what the evidence has been presented. Now, with respect to my client, he told his story. We do have this video that supports him, that says that he reached back. I saw that. It looked very similar to that hand. But what does that go to? Does that go to an offensive touching? And if the court finds it as an offensive touching, there is a defense to offensive touching, a self-defense. Since you going up touching somebody, they can yank back. They can. He didn't go forward and start beating her. He didn't do that. So if everything happened the way if he was so upset the way she says he was, then you would think it would escalate even more. If she did all this, if he did all, you would think it would go more, which we did not see that. What we see on the video is that my client does go back around. He leaves, he exits. We don't see where this dog pounding is occurring, where all the men jump on top of him. We don't see where he's so out of control, where he has to be restrained. We don't see that whatsoever. That is not in the tape. What we do see is two men who were having some type of disagreement. Absolutely. We see Officer Shane approach. Absolutely. We see her go down. However, and I can see if she goes to touch somebody, hey, don't touch me. I can see that. That I can see. But is that an intentional touching, or is that a self-defense to say, hey, don't touch me? A lot of people, somebody comes up to you in the middle of something, hey, just stop. So that is, and I say, if you find that it was an offensive touching, I say he has a defense, and that's self-defense. It's absolutely self-defense there. And that's what I'm saying on behalf of my client. I'm asking for a not guilty. If people have not met their burden, that I will say this, if the court finds that yes, it was, it's a self-defense. It was a reaction to what had happened to him. It was not this, he was not the aggressor towards Officer Shane. That did not happen here. What happened was he was in a discussion with Mr. Sewell. I won't go through it again. You can always watch the tape again. But Your Honor, it's my prayer that this court comes back with a not guilty. Thank you.
Rebuttal?
Yes, Your Honor. So, Your Honor, as the court is aware that defendants are afforded constitutional rights of remaining silent. And Your Honor, in this case, Mr. Morris gave up his right and actually agreed to testify as to what happened. And I want the court to focus on the detail and the testimony from Mr. Morris, because what stood out to the people is that Mr. Morris got on the stand and he testified as to Officer Shane putting him in a full Nelson. I think that was his testimony. I'm sorry, I keep saying full. I'm sorry. Like that, a half Nelson. His testimony was Officer Shane putting him in a half Nelson. So, Your Honor, I'm going to try to quote this honorable court. I don't remember word from word, but I'm going to try to quote this honorable court as one of the terms the court likes to use. And the people believe that Mr. Morris's testimony was so wholly incredible, that it shocked the people's conscience as to what he testified, because the court saw the video, everybody saw the video, that video was played about 10 times in this court. And nowhere in that video, Your Honor, nowhere in that video did the court see Mr. Morris describes as a half Nelson being drugged. I think he testified 10 feet from where he was standing over to that printer. In no way did the court see Officer Shane drag Mr. Morris from the door of the office over to the printer. That testimony was so wholly incredible, Judge, that it's actually disrespectful to the court for Mr. Morris to actually get on the stand and even give that testimony. Because we all saw the video. And nowhere in that video was there any demonstration of any half Nelson and Mr. Morris being drawn from the office to the printer. And so I'm going to ask the court to actually discredit his testimony, because that's not what happened, Judge. What happened was there was an argument between Mr. Sewell and Mr. Morris. Whatever the argument was, that's not why we're here. We're here because Officer Shane, doing her job as a DPS officer, came to try to de-escalate the situation. And for whatever reason, Mr. Morris was upset about the conversation. He was upset about what happened. That's not why we're here. Why we're here is because Officer Shane tried to do her job, and Officer Morris, upset during the argument, upset about whatever the discussion was, pushed Officer Shane, whether it was her body, her person, or her hand. It was an offensive touching to Officer Shane. She did not consent to that touching. And the people are going to ask this court to find Mr. Morris guilty of count 1 assault and battery. And Judge, I also would like to leave with this. Defense counsel mentioned that was a self-defense claim. A self-defense claim is an affirmative defense.
no weight on that testimony, nowhere in that testimony from Mr. Moore did he say, yeah, I pushed Officer Shane because she pushed my hand or put me in a half Nelson or whatever the case is. He never admitted to doing anything. So I'm gonna ask the court to discredit that, self-defense claim as well, because that's not what happened. Thank you. All right.
Court has had an opportunity to consider the testimony of the witnesses, the arguments of counsel, to receive the exhibit of the people. I'm ready to render my verdict. Court rule requires in a matter tried by the bench, the court must make a factual finding and any conclusions of law on the record, and so I will do that. People have the burden to prove beyond a reasonable doubt. That on or about December 16, 2019, within the city of Detroit and the county of Wayne, that the defendant, Lorenzo Morris, committed one count of assault or assault and battery. In order to meet its burden, the people did call 3 witnesses. And those witnesses testified as eyewitnesses to the incident that occurred at the high school in the principal's office, where there was an argument between Mr. Morris, the defendant, and the principal, Mr. Sewell. All the witnesses testified that the argument got very heated. All of the people's witnesses testified that the argument was very heated. Ms. Tillman, the vice principal, testified that it got so heated that she stood up from her desk, that she became concerned, that she followed them out of the office. And then I'm going to skip to Mr. McDowell testified that he was in another area or just kind of off, to the side over there, that he also heard this heated argument, that it caused him concern and that it caused him to come forward towards the disruption. His testimony was that Officer Shane reached the disruption first, that they both were going to the disruption, but Officer Shane reached the disruption first. Officer Shane testified on the first day of the trial that she was in this other meeting, I think, and then she testified about, the sub meeting in Ms. Tillman's office she was not a part of. But that she heard this loud disturbance, and then she saw a heated exchange when she went to intervene. The defendant gave up his right to testify, his right to remain silent, and he did testify, and the court will get to that a little later. So whenever the court is given the task of being the only juror, I like to remind myself of the instruction that I give many days to the 7 or 8 people that sit in the jury box from time to time. And that is the criminal jury instruction 3.6, where I indicate to the jurors that it is their job to decide what the facts of the case are. And in this case, I am the only juror. I must decide which witnesses I believe and how important I think their testimony is. I do not have to accept or reject everything a witness said. I am free to believe all, none, or a part of any person's testimony. In deciding which testimony I believe, I should rely on my own common sense and everyday experience. However, in deciding whether I believe a witness's testimony, I must set aside any bias or prejudice I have based on the race, gender, or national origin of the witness. And then I jump over for myself to number 4. And it says, sometimes the testimony of different witnesses will not agree. And I must decide which testimony I accept. I should think about whether the disagreement involves something important or not, and whether I think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, I may conclude that a witness deliberately lied about something that is important to how I decide the case. If so, I may choose not to accept anything that witness said. On the other hand, if I think the witness lied about some things, but told the truth about other things, I may simply accept the part I think is true and ignore the rest. With respect to Mr. Morris's testimony, he gave up his right to remain silent and he testified. And I just don't know what to say about his testimony. Mr. Morris testified contrary to the 3 witnesses and the video. So he testified, not only did he testify contrary to the 3 witnesses, he testified contrary to the video. Mr. Morris's position, without explanation, continued to be that I wasn't seeing what I was seeing. That was his, he kept telling me that I wasn't seeing what I was seeing. That Officer Shane put him in a half Nelson and drug him across the room. Now, I'm not even as concerned about the half Nelson. I'm talking about the dragging across the room. Now, Officer Shane testified, and she said he pushed her. No other witness said that he pushed her in the chest. She specifically said he pushed her in the chest. No other witness said they saw that he pushed her in the chest. And then the witnesses said that he was aggressive, that he was loud, and that he pushed her hand away at the very least. And then one of the witnesses said he pushed her hand away so hard that he yanked her hand back. Not one witness, including the video, said that Officer Shane drugged, that they went across the room. Not even that he was drugged across the room, but just that they went across the room. That the tussle ensued and they went across the room. There is nothing on that video that shows Mr. Morris at any time at the bottom of the screen near the copy machine. There's nothing that shows him walking from the bottom of the screen and then getting back in the middle of the screen, where he then goes to the back of the room, where we can see, I was gonna say clearly, but we can see his hands go up. I guess that's, when they're telling him to leave. So I'm a reasonably intelligent person. But when an individual tells me that that something is there that is not there, or that something should be there. Now the video is not a smooth video. It's clearly skipping seconds. It's skipping seconds. It's not one of those videos where you're just looking and it's a movie. It's skipping seconds. So the people are moving like this. But they're not moving like this. There are no 5-second breaks in the video, which is why I specifically asked Mr. Morris, how long did it take for her to drag you across the room? And then if she drug you across the room and that took 5 seconds, at what point, why don't I see you in the video leaving from that copy machine that's in the bottom, because I'm gonna tell you, I thought he was gonna say what I thought was a copy machine in the back of the room. I thought he was gonna say she drugged me in the back of the room. He said, no, she drugged me to the corner. His testimony is so wholly incredible that it is unbelievable. In fact, it's just not true. Okay? So what do I do with that testimony? Well, now I have to decide if he lied about something that was important to how I decide the case. So let's see. He said the officer, acting in her official capacity as an officer, came up to him and put hands on him. He didn't say it like that. He said Officer Shane, who was acting in her capacity as Officer Shane. I wrote something down because it came to my mind when this testimony kept going forward about Officer Shane hitting him. And I said, or pushing him, or putting him in a half Nelson. And I said, it's the defense's position that Officer Shane was an unwanted interloper. That's what I wrote. Now, you all never said that. That's what the testimony was putting forth. That Officer Shane was an unwanted interloper. Counsel's questions, she was saying, well, did you invite her there? Did you ask for help? Did you? But Mr. McDowell, nobody asked him to help either. But he said, I heard it, I saw it, and I was on my way to stop because these two grown people acting like kids. He didn't say the acting like kids part, I added that. I saw it, I heard it, I was on my way to intervene. But I stepped back and let the officer act in her official capacity, the officer who had the authority to arrest Mr. Morris. So now, counsel's statement her argument as to the self-defense. I don't know how you could self-defend when a police officer is telling you to stop. I don't know how you could self-defend. Because that seems like it becomes assaulting, resisting, obstructing. So I don't know how I can self-defend if Officer Shane come in the middle of us and rightfully say, stop, stop. And if she hit you, you're supposed to stop, stop. If I touch you, stop. You don't get to say, right? So what's the difference? Because the record won't know. The first one, I hit my hand, I hit the hand. You don't get to hit the hand. And you don't get to yank yourself away from the officer acting in her official capacity as Officer Shane. So number one, I discounted everything that the defendant said, which means I discount that she put her hands on him first. So you want me to believe Officer Shane put her hands on him first, but you also want me to believe that this video forgot to show him being drugged across the room, down to the bottom of the printer, and then he left and ran around the table. Now, what was astonishing to me, this doesn't have anything to do with the case, is that that lady in the beige, she used to y'all fighting. Whoever the lady in the beige was, she did not move, she did not duck, she did not do anything. She sat right there and did her work. And she's like, y'all ain't gonna, I got work to do and I'm not gonna move. Everybody else was running around her. And I didn't see any big difference in her position that would say, oh yeah, it's about 10 seconds missing from that video. Now, you and I both know that don't make any sense. It didn't make sense when you said it, and it don't make sense right now. The court does not believe what Mr. Morris testified to. So let's go back and see then, did the people meet their burden? The people testified, the witnesses testified that there was an argument, and that at the very least, and I'm not gonna say I don't believe Officer Shane that she was pushed, somebody could have pushed her, but it looked like a lot of stuff was going on in the video, right? But the two witnesses said they saw Mr. Morris hit her hand or push her hand away, right? So she reached out and they saw him push it away. And that is enough for the people to sustain their burden. And therefore, the court is going to find Mr. Morris guilty of one count of assault or assault battery. Having found Mr. Morris guilty of one count of assault or assault battery, normally, I might, since the complaining witness, since the victim, she's not the victim, I guess officially. So since the victim is present, I would offer an immediate sentencing. However, let me tell you what I observed, and I'm gonna order a pre-sentence investigation. I observed that Mr. Morris has anger issues. I observed that Mr. Morris, is in some way, shape, or form, I don't know. I don't know what to say about the testimony about the, being drugged. I don't. What I do know is that Ms. Webster Cox is an aggressive advocate. Ms. Webster Cox, in my experience, have not left stones unturned. That's just my experience with your lawyer. I don't know when you told her, I don't know when that information came, but what I'm saying is, it's my experience, and I could be wrong in this occasion. I'm not saying maybe she slipped on this occasion. I don't know, but I think that maybe if she thought, the video was tampered with, because that's what you were saying without saying it, I feel like I would have got a motion. I don't know though, maybe she was busy. I don't know, right? Okay. But what I'm saying is, or maybe you didn't give her enough information to make her want to come to me with a motion like that, because she was like, the judge, I'm gonna say something. But that hasn't been my experience. And she fought very aggressively for you during this trial. But Mr. Morris, you're not living in a reality some type of where. So I'm saying all that to say that even though Officer Shane is present today, I'm going to set the matter for sentencing. I would like a pre-sentence investigation so that I can make a determination as to what the appropriate sentence is. But I can tell you off the bat, it's going to include a lot of anger management, more than 12 weeks. It's going to include that. I can tell you that there was a question that said, did he have any issue with Officer Shane on that day? And he said no, but I didn't believe him. Because he got so heated up when the question said, did you have any previous encounter with her? And he was like, yeah, she be talking to me like, that. She's an officer. She's an officer. I mean, she's supposed to come in there and be talking, not, all soft and stuff. But he was like, yeah, she was talking to me wrong, but okay. No, so honesty goes a long way. So the question might have said, well, yeah, I have some, issues with her because she's too aggressive. That was probably the right answer. I got some issues with her because she's too aggressive. She be coming in there talking to you sideways. Well, people, I think I might be the only one you sideways, but she come in there talking to you aggressive. So I would like a pre-sentence investigation, so I could get a better picture of Mr. Morris and that I don't judge him unfairly as it relates to, anything dealing with the case. The sentencing is serious and I don't want to judge him unfairly. So I'm going to order a pre-sentence investigation and a substance abuse evaluation, and then we're going to set the matter for sentencing. And I I know my docket is so full, but between my docket and Ms. Webster Cox's depositions, let's see if we can, let's see if we can get a sentencing date this year. Okay, I mean, honestly, my November is like hit. November is hit with, I just don't think I have any time in November, but let's go to the 1st of December. All right. How many, Ms. Ritter, is Aaron Hicks going to trial?
The court has a final pretrial set requirement.
I know. Don't you know your witness, that he's coming, that's the one that.
Right, I haven't received.
See, okay, let's just, okay. How many do I have on December 12th though, outside of the Hicks trial?
A total of 5.
Oh, I just have 5?
1 jury trial, 2 pre-trials, and final pretrial.
Oh, that is listen, if you can make December the 12th work, that would be the greatest day.
Can we possibly, can it be in the,
Oh, yeah, it could be in the afternoon.
so if it could be in the afternoon, because I have a facilitation starting at 12:30. So I'm thinking.
Well, that sounds like you need it in the morning.
But I also have a case evaluation from 10 to 10:30. So.
Well, you know, I'm real timely, Ms. Webster, so if we set it at 9, I mean, retained counsel, I usually get you all in and out. And it could be, well, depending on if your client, it could be on Zoom.
They could have, if it's on Zoom, I can do it, it's fine.
Well, it's up to your client. So, Mr. Morris, do you consent to being sentenced on Zoom? Yes, okay. So, that should be a clue that I don't intend to put you in jail. Otherwise, I'd be like, no, you gotta come in person. Okay, so let's do December 12th at 9 o'clock on Zoom. I am, as I said, gonna order the pre-sentence investigation. So since he's in the building, Ms. Rutter, if you could go ahead and hurry up and send the order across the hall, and then they can schedule it while he's here. That way they don't have to try to play phone tag or nothing. But if they can't, I mean, maybe they shut down for training or something, you know, some stuff they might do, but I don't think so. We can make sure that we have his address and phone number in case for some reason he can't schedule that today. They will need to get in touch with him. And then Officer Shane, you are the victim, and therefore on December the 12th, you do have a right to come and make a victim impact statement if you want. As we just said, it's going to be on Zoom, so you can log into Zoom if you would like to make a victim impact statement. And if you don't want to make a victim impact statement, but you just want to come, you can do that. It's up to you. Anything further?
Nothing from the defense, thank you.
All right, then we're all set. Let's call over there and see right quick if he can come over. Yeah, see if he, not to do the, you know, but just to schedule it, or do they just want to call him? All right. What? Yeah, we finished. Well, Ms. Stevenson, she held on, so it might be something for you, so come back. Ms. Stevenson, she told me to end Zoom.
You can, I just forgot to turn it off. I'm really sorry. I'm sitting
You're
here.
just not here, you really not.
I'm really not here. I didn't even really realize this was still on until you just called my name.